Hello, everyone. I would like to introduce our next speaker, Pat Mellen, an attorney. And Pat is a very interesting person with diverse background. She obtained a Bachelor of Science in Industrial and Operations Engineering from the University of Michigan, followed by a Master of Arts in Journalism from the University of Missouri with an emphasis in investigative journalism. And then more recently, a Juris Doctor from the University of Denver Sturm College of Law with a certificate in environmental and natural resources law. So a very broad educational background Pat has. She was admitted to practice law in 2017 in Colorado and in U.S. District Court for the District of Colorado, and also in August 2018 for the 10th Circuit Court of Appeals. Earlier in her career, Pat was a background investigator for the United States Investigation Services who clear people for security clearances. She was in field positions to support the Office of Personnel Management's National Security Clearance Program. Then she did this similar kind of work for a contractor, CACI International in Arlington, Virginia, doing background investigations, again, for the Office of Personnel Management Security Clearance Program. Then she became a lawyer and interned with the probate court for the city and county of Denver, and did contract attorney work for the offices of Randy Weiner in Boulder, who's an attorney, working on Rocky Flats related matters, and more recently under her own firm, Pat Mellen Law, LLC. She's an attorney representing clients in conflicts involving property, drug lab damage, construction defects, contract breaches, trespass, etc. And most importantly, Pat has petitioned for the release of the records of Colorado Special Grand Jury 89-2, which was impaneled to weigh the evidence from the FBI raid on Rocky Flats in 1989. Those grand jury records have been sealed ever since, but they are highly relevant to today's events, and Pat has boldly petitioned for their release. And she's going to review the history of litigation related to Rocky Flats. So everyone, please welcome Pat Mellen. Thank you.
Hello, my name is Pat Mellen. I am an attorney based in Denver, Colorado. I do environmental and property law, which means that anything that I work on has a property angle to it. I'm a litigator, not a transactional lawyer, so I don't put together deals or try to sell property. I deal with the fallout when property situations go wrong. And if there is a property situation that has gone wrong, in this area, it is Rocky Flats. And so I've been an attorney since 2017. Rocky Flats is a lot of what drove me to go to law school. I used to drive by it in my old job, which was working in the national security clearance industry. And I would see a very interesting dichotomy at the corner of, I want to say, 90th and maybe 95th and Indiana, where on one side of the corner, it would be Candelas signs, people with those Rocky signs saying, build a house here. And across the street from them were people with the same Rocky signs, the signs that you go like this with, saying, no Plutonium Parkway. So that was a really interesting, that was my introduction to Rocky Flats. And it's an interesting way to think about how polarized the views are about that site. And that plays into its legal history. I've done a fair amount of research. I'm one of 3 attorneys here in Denver who really spend a lot of time litigating on behalf of the advocates and the local communities on sort of 3 separate areas. And we try to sort of parse those out so we're not trying to go after the same thing at the same time. Those 3 areas tend to be the refuge, which has its own unique set of land use issues and a little bit of historical problems. There's also then another attorney who takes on things like the Parkway and the Greenway and some of the interactions between Rocky Flats and the community, local communities. And then I focus my efforts on the residual contamination left at the COU, the Central Operable Unit, and sort of the future of that contamination and the stewardship of the site. And so what I'm here to talk to you about today is a project that I started in 2016 as an independent study at the University of Denver, Stern College of Law, about the legal legacy of Rocky Flats, because it's far more extensive than most people are aware. We have not had a lot of wins in this project. There's been a couple that I'll touch on briefly, but that doesn't mean there hasn't been an extreme amount of litigation attempts for the public to have a voice. And that's really what the issue is here. You'll see I've listed 4 basic areas: property claims, environmental and public health, accountability, and unique issues. And that's sort of a catch-all for things where there's been a unique problem that litigation has been used to try to solve. And then I'll talk a little bit about the legal obstacles that we have to overcome to have this litigation have actual effect. There is no negotiation in this situation at all. The agencies, the federal agencies who currently own that land really have zero interest in negotiating anything. The activists who have worked on this, including most recently the Rocky Mountain Peace and Justice Center, EIN, the Rocky Flats Homeowners Association, the Downwinders, those groups have all made incredible efforts to try to work with the local agencies who currently are the federal agencies that own this land. And the agencies have put in place many processes that look great on paper, that make it seem like there's public input or public direction about what's going on, and there really doesn't happen. It's a shame. So I'd like to talk a little bit. Let's start with property claims, because that's where we actually have had some success, and I use that "we" very generously. It was years ago. The biggest and most famous of those cases is the Cook v. Rockwell case. It was started in 1991, right as the raid had completed. It was concluded only in 2016. So that's 25 years of litigation, where several large class action law firms helped put together, and then finally came down to 2 firms, one out of Philadelphia and one here, that got in the end a $325 million settlement with Rockwell that has either been or is in the process of being completed, dispersed to local property owners for the diminution of value for their properties. That's where property loses value because it's been contaminated. And most of what those claims are related to were the 2 fires, where the Cray-Hardy maps will show you that contamination was spread east and a little bit north, I guess, if I'm going from memory. But there were properties where the plutonium that went up through the smokestacks and the fires, where that plutonium landed on properties and in fact diminished their value. The other big area in property claims is things like mineral rights and other diminution of value for the Church McKay folks. This property was acquired back, I want to say it was in the 50s, maybe even earlier. I guess it was earlier. But it was acquired from the Church McKay family substantially, and there were arguments about the price that would be paid, and then later additional land was purchased to increase the buffer zone, also from local landowners at the time. And so arguments about what the price would be paid, what effect it would have on other adjacent properties, those have all been litigated through property claims. And honestly, those are the easier claims to win because the causation factors are less. You have a property where there's either plutonium or there isn't, and that's a test that can be run. And plutonium does not occur naturally in nature, and so it had to come from somewhere. So those types of lawsuits, the Cook v. Rockwell went on for so long because there were so many claimants, and the amount originally awarded, which was over $900 million, that's a big number worth appealing. And the rounds of appeals went on for decades. The biggest issue of current activity for legal work is in the second box, the environmental and public health. Land use is the question now. How will that property ever be used again? And that is the single biggest flashpoint for disagreement about whether the property is safe for unlimited use and unrestricted exposure. And that is the catchphrase, unlimited use and unrestricted exposure. And that's what the refuge, the designation of the refuge after 2006. The refuge was created in 2006, and stewardship of that, management of that property, was given to the U.S. Fish and Wildlife Service. The federal government still owns that entire property, and it doesn't differentiate between the agencies that are actually used to manage it. So Fish and Wildlife manages the refuge area. The Department of Energy still manages what's called the COU, the Central Operable Unit, which at the moment could be considered at least temporary for the time being, sacrifice zone. So there's no access. It's strictly a management process where contractors such as Navarro are out there trying to sort of, with duct tape and Band-Aids, keep the COU from leaking anything into somewhere it shouldn't go. But environmental and public health claims are very difficult. So what we're up against here are things like causation, we'll talk about in a minute, but environmental claims are being run trying to use environmental law, NEPA and CERCLA and RCRA to talk about how the residual contamination or the disturbance, more importantly, of the residual contamination, either on the surface or slightly below it, will affect both the environment immediately around it and the public who are then permitted to be exposed to it. So, for example, NEPA requires some strict analysis to happen, environmental assessments to be done before changes are made. And a lot of the current litigation that you'll read about has to do with failure to complete those environmental analyses correctly. It's a procedural claim. It's very difficult to win because of what we'll talk about in a minute is agency deference. Public health is the real stickler here because public health requires an attorney and a claimant to prove what we call causation, that the health effect that is damaging a particular person can be directly linked to the exposure to residual contamination from that site. And proving causation is one of the single hardest things in any kind of environmental law, that your exposure as a human being to a particular contaminant or a particular infection or virus, and that specific thing, that specific exposure is responsible for your injury is extremely difficult. There have been several cases in this area brought by both the Rocky Mountain Peace and Justice Center, other environmental activists, and by the local communities, and they, almost without exception, have not succeeded. Let's talk a little bit about accountability. There have been cases brought by the actual contractors, for example, Rockwell International, who was managing the site for the Department of Energy at the end of its tenure. So back in the 91, 93 kind of timeframe, Rockwell sued the Department of Energy saying, we cannot run this site that in a way that is both compliant with a contract that you're requiring us to enter into and environmental law. And they lost that suit. And so there's an attempt through legal means to hold the Department of Energy accountable for its work out there. The biggest issues that come into play for any activity in that area at this time are statute of limitations. I mean, the activities at the site right now are strictly monitor and maintenance. So everything that happened back while the site was still operational is well beyond the statute of limitations for us to take any action at this time. That includes the cleanup. And the cleanup is a whole separate topic about the compromises that were made, both for money and time and for greenwashing that happened as a result. And so the accountability side of this is really sort of behind us. There's not a lot we can do to hold DOE accountable for what happened there. Excuse me. Unfortunately, what would have to happen in order for us to take any more steps on the accountability side would be that a failure of the remedy, a failure of the containment of the residual contamination. And for those of you who are not familiar with how the cleanup was completed, is that there's still much contamination still buried underground in several of the buildings that were simply imploded and buried and left out there. And the information is available out on the Rocky Flats Legacy website that shows where contamination was buried and left behind. The cost and the time and the political will didn't exist at the time to go through and actually take all of it out. There also was not a agreed upon destination for where all of it could go. So we could dig it all up and contain it in containers to be shipped, but where would you take it? And that was sort of the catch-22 that ended up happening with Rocky Flats. The problem is that the system of containment they left in place causes great concern about whether it will fail. I mean, the Marshall fires brought all of us back to that same level of concern about, well, if the Marshall fires are attributable to coal fires underground, how far away are they from Rocky Flats, and could that ever cross over and cause problems? So a containment failure is the likeliest thing that would give us cause to take more litigation steps in the accountability areas. Short of that, we've really run the statute of limitations. And then unique issues. Unique issues are things like Jim Stone's whistleblower cases, where during the actual operation of the plant, some of the more vocal workers or contractors out there tried to make a difference, and Jim Stone is one of them. And so he brought a series of cases and appeals that talked about the pondcrete creation and whether it was working or not. And that's part of the disposal of contamination. We also have a lot of civil disobedience cases out there where the activists back at the time that the plant was operating were making dramatic stands. They're the encirclement of the property and other attempts of, sitting on the train tracks. I think of the pictures of Leroy Moore sitting on the train tracks, trying to block the shipment of, toxic waste. And so those unique issues are things that we can look to for precedent. The single biggest current unique issue is one that I'm personally involved in or professionally involved in, and that is the attempts to obtain the grand jury documents. And so after the FBI raid in 1991, after the grand jury was impaneled in August of 1989 after the grand jury, or after the Rocky Flats raid, also in 89. They impaneled a grand jury attempting to determine if there were criminal claims that could be brought. Grand juries, as a matter of course, are the documents and information and testimony and proceedings are all under seal. We've made one attempt so far, and I emphasize so far, to obtain the documents that were sealed in the grand jury, mostly because we believe that they will provide information about the burial or other hiding of contamination, of contaminated waste that's still out there, unfortunately, on the refuge area, where documentation was very poor. The sampling that was done to clear the refuge was 5 samples per every 30 square acres. And so we believe that that sampling was insufficient, and that if we can prove through those documents that there are specific exact locations where contamination remains, we can reopen and revisit that sampling and clearance of the refuge. The outcome of our efforts to obtain the grand jury documents so far have been unsuccessful. Unfortunately, the Department of Justice says they actually don't know where they are. That was the outcome of our last attempt. That's a bit concernful, that the Department of Energy and the Department of Justice are either unwilling or unable to tell us where those documents went, to the degree they can't even give us a piece of paper that says, after the grand jury was done, here's where they all got shipped to, right? If you think about the bureaucracy of the federal government, the concept that there's not a receipt, there's not a check stub where they paid anyone to move those documents from point A to point B, is really sort of not credible. So we believe that those documents still exist. It's a matter of finding them and having a good and sufficient reason for those documents to be released to us. The release of grand jury documents is very precedential, and so it's very difficult to obtain. But stay tuned on that matter here in the next year or so. I'd like to talk a little bit about legal obstacles that lawyers think about when we look at bringing cases in these areas. First and foremost is governmental immunity. This applies at the local and the federal level. In general, suing your federal government or your local governments is very difficult. There is immunity provided to the government that says that they have to make bad and ugly decisions and trade-offs, and they're making the best decisions they can, and therefore they are immune from lawsuits because you disagree or I disagree with the decision that they made. That mostly applies to the Department of Energy and to the local communities like Jefferson County or the city of Arvada about decisions that they made. Agency deference is a different topic. Agency deference says that a court, when reviewing a particular claim, a particular lawsuit, tends to look at agencies such as U.S. Fish and Wildlife, the Department of Energy, as experts in their fields, regardless of whatever expertise is available to the advocates and the legal community who are, raising questions and bringing claims. And so it's very hard to overcome agency deference, which says the U.S. Corps of Engineers knows how to manage the waters of the United States, and their decisions are given extra weight because they are considered by default experts because that's what they're, in fact, employed to do. And so overcoming agency deference in the court system is very difficult. We've talked a little bit already about causation, where linking, and it has to be a direct link, scientifically proven between exposure to contamination and actual illness. Now, Physicians for Social Responsibility is at the forefront of this concept, where the testing of downwinders and the testing of the local communities and linking particular physical ailments to the exposure to particular plutonium. Now, plutonium can be tracked to where its source was, and so the plutonium at Rocky Flats has a signature, my understanding anyway. And so that is an area that I know that the Physicians for Social Responsibility is certainly making an inroad. Statute of limitations has to do with the fact that after a particular period of time, you have waived a claim that you haven't brought. And so environmental hazards, breaches of contract, negligence in management of how the Fish and Wildlife Services manage a particular area, all have statutes of limitations. So we can't go back on what happened at Rocky Flats in the beginning, but we have to focus on looking for ways to use current changes and current problems to readdress, to the degree we can, old harms and bad things, bad decisions that happened. Res judicata is a concept in law. I was trying not to use a Latin term, but res judicata says it's already been decided. So there is a real tendency in the legal field to apply prior rulings to new questions. So if there is a precedent established that says, here's how the judiciary treats this kind of claim in these circumstances, it is next to impossible to get a new judge to rule a different way. Law is built on prior precedent, and that's not just at Rocky Flats or environmental law. That is in every legal case in front of a court. And so we are trying to overcome, 30, 40 years of precedent that this site, while no one is enthusiastic, well, few people are enthusiastic about the decisions and the choices that were made either before or as we were learning about the harms they were creating, there's legal precedent that it is allowed or it can't be changed. And so res judicata is something we have to find reasons why a new situation is different than an old situation that could not be solved. Societal pressure is more of the social marketplace, and this is an interesting thing for us to overcome at places like Candelas or Whisper Creek. People, the demand for homes, the demand for affordable living, the demand to believe that your house is safe, the denial, psychological aspects of denial that there's not a harm sitting next to you so you can sleep at night and that you're not exposing your children to an unusual risk. Those are very strong psychological factors. And so you'll hear a lot of pushback from places like Candelas or Whisper Creek that go against trying to support a finding that there's any harm or any exposure still happening at Rocky Flats, because that puts their investment in their home and their property and their livelihoods at stake. And so while the legal legacy, I guess, to sum up, is one that is very complicated, there are many issues that we would still like to address. There are several lawyers who are very much interested in helping out the local communities and the local activists bring claims that are possible. We are honor bound as the guardians and gatekeepers of the legal system, that any claims that we bring, suits that we file, have to be substantially supported by evidence and law. So we can't just throw claims out there, but to the degree that there are valid claims about the way that site is currently affecting the communities and the population of the area, and to the degree that the site is being managed responsibly and safely, we certainly want to keep hammering away at those claims. It's been decades since the site was shut down. We've learned a lot about what bad decisions were made in the beginning. We're hoping to avoid learning about bad decisions made in the containment through a failure of that containment and exposure to people who will in fact become sick or otherwise damaged. So if you have questions, concerns, want additional information, you can reach me at my law firm, Pat Mellen Law. My email address is pat@patmellenlaw.com. And I'm happy to answer questions to the degree I can or provide additional information. And I thank you very much for your time and attention today.